Tax Weekly Update. We are here today from Houston, Texas, bringing you the latest immigration news and employment-based to keep you updated of what's going on. My name is Emily Newman, the managing partner of Reddy Neumann Brown, and with me today is Stephen Brown, also the partner at the firm. Stephen, what topics are we going to be covering today?
Yeah, we're going to talk about H-1B compliance mistakes that can cost the company, cost the employee, and what employers need to know, especially in the age of enforcement. We're going to talk about startup H-1B trends and what's working so far. And we're going to talk about changing status to F1 and what you need to know before changing status to being a student visa from what you are today.
All right. And of course, as always, we will be taking your questions live. So be sure to put those in the chat. And I want to give a little plug for our podcast. Since I have Stephen on with me today, you may not know that Stephen and I have a podcast called Visa Vibes, where we talk about all things employment-based immigration and what's going on. We are on YouTube, we are on Spotify, Apple Podcasts. So check out our podcast while you're at it. So with H-1B, go ahead.
Yeah, we try to keep it topical, with what's trending, but also kind of a laid back view on things, not too heavy handed with it. So take a listen. And if you have topics, let us know.
For sure. All right. So H-1B compliance mistakes that can cost you. We are in the Trump era of things. We saw Trump 1.0 where there was definitely more enforcement, more site visits. I think that will continue. We've even seen recently Tom Homan, the border czar, saying that they're going to drastically expand enforcement on employers, such as I-9 enforcement, with everything that they're doing with undocumented immigrants, detaining, and all these things that are going on around the country. I think it's close to time where employers are going to be involved in that as well. So of course, I-9s is a different topic, but from an H-1B compliance standpoint, we expect more extreme vetting on that. One of the topics that comes to mind for me is the LCA. So every H-1B needs to have a valid labor condition application that covers the work location where the worker is actually working. It mentions the job title, the salary, the occupation code, the prevailing wage, the wage level that was used, confirms that the employer has not had a strike or lockout, there's not been a layoff, and all of these things. But one of the things that keeps coming up is when employees change work locations and no new LCA is obtained and no new amendment is filed. So under matter of Simeo, which has been on the books for several years now, USCIS requires that when the work location changes to a location outside the location covered by the current LCA, that not only does the company need to get a new LCA for the new work location, and they need to post notice of filing at that new work location, but they also need to file an amended petition. And we're hearing of cases where 2 years go by, an amendment was never filed. The person's been working in the wrong location the whole time. USCIS figures that out. They see it when you file an extension and your driver's license has one address on it, your paycheck has a different address on it, the I-129 has a different address on it. They start asking questions and realize that the LCA was not complied with. They may find that you violated your status and deny the extension. Now they can still approve the petition just without an I-94, meaning it converts the case to consular processing. But now you have the hassle of exiting the US, going for visa stamping. If you don't have a valid visa, getting stuck with a 221G, who knows how long, and then finally coming back to regain your status when a simple amendment could have fixed all of that. So besides amendments, what other issues are you seeing in terms of compliance that people should be aware of?
Yeah, Emily, and real quick on the amendment thing, we've seen communications from the government where they are, for lack of better words, information sharing with agencies that they haven't previously. And we're talking, IRS and Social Security and stuff like that. And so, if your H-1B is supposed to be in Dallas, Texas, and your taxes are in New Jersey, with all this information sharing and the AI and all that they're doing, we might see things even when you don't have a petition. They might send a site visit. So just stay on top of that. Also with regards to making sure your public access files are up to date, they are doing these site visits through FDNS, the Fraud Directorate, and looking into ensuring companies are following the rules. And it's tedious but not hard. The rules are very well written out. We keep our clients informed. Department of Labor has information, on how to make sure you're complying with the LCA requirements for the public access file. And it's not that they want to catch you and say, slap you on the wrist and say you've been bad. They want you to follow the rules. So they make it, they give you the answers to the test. You just got to follow it.
Yeah, and I think another thing people need to be aware of is kind of the current, not just the environment of the Trump administration, but also the public. I mean, there's a whole group of people that are kind of anti-immigrant, and they are willing to report things to ICE, report things to USCIS that they think are wrong, whether they're right or wrong or not. And so just anything that is potentially, not in compliance, you're just opening yourself up to that scrutiny. And there's going to be more scrutiny. We're also seeing more scrutiny in these site visits. And as a reminder, so FDNS, Fraud Detection National Security Directorate, is now mandatory for employers to comply with as of January 17th, 2025, whereas before it was voluntary. And so, I think a lot of times now site visits are happening more contacting the employee directly, may not be so much through the employer, because they want to get the real story of what's actually happening. So they're not just going to, let you ask you for what is your job description and let you just copy and paste the job description from your petition. They want to hear what the job description is in your own words. What are your actual job duties? They want to know, how often are you reporting to the office? They're going to ask you potentially, what was the education required for this position? How many years of experience did you need for the position? Why are they asking that information? They want to make sure that the company chose the correct wage level on the LCA, because the company, the LCA, the company gets to fill out and the company gets to select the wage level. Of course, they're supposed to go through the prevailing wage guidance worksheet to select the appropriate wage level. But if they're saying the job requires a bachelor's degree and no experience, and then the employee comes and says, no, that I was told the job required a master's degree and 5 years of experience, the company may be questioned on whether they chose the correct wage level, because it maybe should have been level 4 instead of level 1 or 2. They're also asked, go ahead.
Yeah, and on that, with the education level, I have had communication with FDNS officers who, they send it to our client responds, and then they says, okay, that matches what the third party client, the end client said as well. So that's good. So they're checking every level of this, to ensure that it's that way. Now, debates on whether that's right or not, but it's how it is. And so make sure, you go through that prevailing wage determination for these cases. Don't just say, oh, it's a level 1. Go through. It's not hard. It's a matrix that Department of Labor has, and make sure the determination is correct.
Yeah, another thing that we're seeing site visit officers ask now is, how did you find the job with your sponsor? What were the steps for hiring? Who's responsible for conducting performance reviews? How often? Why are they asking those questions? I think they are following the Department of Justice directive that is trying to root out discrimination against US workers. So if they're asking you these questions and coming to find out that the company has a preference for hiring H-1B workers over US workers, that could lead to action by the Department of Justice. They're all asking, how often do you communicate with your employer? Is it through phone? Is it through email? Have you ever taken unpaid leave? Were you ever required to pay any part of your H-1B fees? Because that is not allowed. You're not allowed to do that, and it's a violation of the LCA regulations to do that. And then they're asking for the receipts. Honestly, they're asking for your driver's license because they want to make sure you are who you say you are, as well as what your address is listed on your driver's license. They want confirmation of your actual physical residence, bills with the date visible on it, the lease agreement, recent pay statements, plus recent bank statements. They want to put two and two together and make sure that the money that your paycheck says you were paid is actually money you're receiving in your bank account, because there's some bad actor employers out there that generate a pay statement but never give you the pay. That is a violation. Don't let them do that. Stay away from companies that do that. But that is what they're looking for because they know it happens. They're even asking for like screenshots of interactions that you've had with your employer, screenshots of you logged in and doing your work that have a date stamp on them. So this is well beyond what they have done in the past. As an employee, you'll have to decide how much information and documents you're willing to give. I mean, what if those screenshots share confidential information of the stuff you're working on? So definitely you may need to contact an attorney before you respond to those. And it may be a different attorney than the attorney that your company uses. And because there may be a conflict there if you're saying one thing and your company is saying something else. So these site visits are definitely going to bring up more issues and are going to expand.
Yeah, definitely. Emily, I wanted to talk about maybe a good topic, little less negative with FD&S, but startup H-1Bs. In the January regulation from this year, they introduced the beneficiary-owned business regulation where, hey, one, we're going to get rid of this common law definition of employer-employee relationship where USCIS focuses on the company having the right to hire, fire, pay, supervise, or otherwise control. And we're going to turn it to this bona fide job offer, and is there bona fide specialty occupation work? And then an introduction to beneficiary-owned businesses. One of the issues in the past when you have this, it wasn't really prohibited, but it was by law, but it was prohibited by consequence, if you will. And what I mean is, one, if I wanted to start a business, I would have had to get a board who could have the right to hire, fire, pay, supervise me, so I could start a business. I also couldn't run the business. I can only do specialty occupation work, just doing legal work. And Emily, you run the business here. You spend a lot of time doing non-lawyer things to keep the business flow, whether it's, helping with hiring or whatever, or going to the bank, whatever it might be. And so the new regulation did a lot of good in that one, like I said, bona fide employment, bona fide job offer, bona fide specialty occupation. Really, is this real? Is now the standard. Is there really something to be done in a specialty occupation nature? And then number two, they've said, hey, beneficiaries can even be 100% owners of a company, and they can spend the majority of their time doing specialty occupation work and the minority of their time doing what I call non-qualifying job duties, to kind of take from the L1 perspective. So now if you spend 51% of your time doing a job that requires a degree in a specific field, and then 49% of your time running the business, contract negotiation, getting mail, payroll, whatever, that's okay. And truthfully, we've done a handful of these cases, and most people, it's more 80-20, right? Or, 75-25 than it is 51-49, especially when we're talking individual businesses. But they're going well. Now, the one thing to keep in mind, these are 18-month approvals, when you have the beneficiary owned business. And then the second one, the first extension, will also be 18 months. And truthfully, they want to make sure, that this is actually happening. And so what my theory is, maybe they're going to be more willing to, for example, I have a complete startup. We have a business plan that we've obtained now from a company, from them. They've worked with a service to put together a very nice business plan. But in 18 months, USCIS wants to make sure, are you actually doing what you said you were doing? And that's how I'm planning on these, 18 months, that extension, that, hey, how are we actually doing what we said we were going to do, and how are we growing? But we've seen these, they are getting approvals. I do think they require more work than most H-1Bs because they are more nuanced. As a business owner, you're going to have to do the business formations. It can't be a sole proprietorship. It's going to have to be a LLC, an S corp, a C corp, whatever. You're going to have an FEIN. You're going to need a place that you can work. You're going to, what are you actually doing? And it can't just be, I'm doing stuff. They're going to want details to it to be able to analyze it. But it is good. I think it's a step in the right direction because, for years, we would talk to people and they'd want to start their business, but it was so prohibitive on the H-1B side.
Yeah, and I think you already touched on it, but it's really important with these types of petitions to not be vague. You have to actually specify in detail what your specialty occupation job is going to be, point out all of those job duties, and then also what your non-qualifying functions are, and that you're going to spend the minority of your time on those. And then in terms of documents, as you mentioned, a business plan is helpful. I also include, the FEIN letter that you get from the IRS assigning your tax ID number, your articles of incorporation or memorandum of association, lease agreement for your office space, photos of the office space, contracts maybe that you've got signed, purchase orders, bills that you've paid. So just things to show that this is a legitimate business that is up and running and it's ready to support your specialty occupation work. As of this point, I don't know about you, but I've not received any requests for evidence on any of this type of case yet. So I don't know if it's USCIS being more lenient on these for the first petition, the first 18 months. And then when we file the renewal, that's when we're going to see the more difficult RFEs and that sort of thing, which is kind of how it is in the L context when you have a new office L that's been around for less than a year. The first one, I don't want to say it's easy to get approved, but it's relatively easier to get approved, but it's only issued for 1 year. And then when it's time to file that renewal at the 1 year mark, those are much more difficult to get approved because the business is still really new. It's only been around for 1 year at this point, but they want to see the growth of the business, more employees hired and all of that. So I think we might see kind of the same 18 months from now. We might have a different story to tell about how these petitions are going, but right now, so far so good. And then I also want to address just startups in general, not necessarily those where people are kind of self-sponsoring their own H-1B, but can a startup company sponsor other people's H-1Bs? What is the trend there? And really, I think that started more with the Biden administration kind of during COVID, where people were, reassessing life and deciding they want to go out on their own and start a new company, and then bringing over H-1B workers that have that technology and experience that they need. And even those petitions have been relatively straightforward, not seeing a lot of RFEs on that like we used to. If you would file a H-1B petition where the company said they had 0 or 1 employee, and that everybody was working from home, prior to the Biden administration, you would definitely get an RFE asking about vibe documents, verification of business existence. You would get an RFE asking about specialty occupation, who's doing the non-qualifying functions. It would be like a 14-page RFE that we used to get for those kind of cases. And now they're routinely approved. Remote work is not really questioned anymore. The employer-employee relationship's not an issue anymore. You've just got to provide documents that there is a bona fide a specialty occupation, meaning a legitimate company and a legitimate job available. But other than that, those have been relatively smooth so far in 2025.
Yeah, and on these beneficiary owned businesses, Emily, I've really seen two flavors in the last 6 months. You have this is, a complete startup. I've had an idea in my head, or hey, I did this, as my PhD program. I kind of did this. Now I want to turn it into a business. There is no revenue. It's going to be a startup. I've seen that one. And then I've seen, hey, this business kind of exists. Now I want to take more of a role because I can, right? Instead of having, my friend be the owner because we've got to do that for immigration purposes. I've done it. It works both ways. Now, the one thing I want to caveat on this, and I think is going to be interesting in 18 months, is when we're talking about these ones where it's a startup and there is no revenue, you still have to pay LCA wages on it. And so you need to have a plan. Like, what is the growth factor? Because, you're the CEO and that's a high value, prevailing wage. And you're going to have to show that you're able to meet it down the line and that you are complying with that. It doesn't, just because it's a startup. Now, one of the common questions I get is, well, can I structure this as, equity? And unfortunately, that's just not how the LCA really works. It has to be salary, not just, hey, I'm going to take whatever profits. So just keep that in mind. I think it's something, to do a lot of conversations and soul searching and, figure out how to plan it. Emily, one of the other topics I want to talk about is switching to F1. And we see either people wanting to further their education, maybe they're tired of working, they want to go back to school. After I took the bar exam, I don't think I ever want to take a test again. But I get it. There are people that want to go back and further their education. We also have, the probably one of the most unfortunate things in our immigration system with age out kids. H4, L2 dependents, other non-immigrant visa dependents who turn 21, and because of our outdated immigration system, based off of where they're born, their parents can't get a green card and they age out. They can't stay on H4 or L2. And so, they're going to college. Now they're going to switch to F1. I-539, maybe if you're in the U.S., maybe consular process. If you're outside the U.S., premiums available. You work with the school, you get some documents for them. What are you seeing on that trend with F1s?
Yeah, I think the I-539 change of status process has really been smooth for quite some time. I think people still are under the impression that visa stamping is the better route to go. I get a lot of calls and questions and consultations where they initially start the call saying, well, I'm going to send my 19-year-old abroad to get the visa stamp so they can come back on F1, and all of their questions are related to visa stamping. And I'm like, well, why are we doing visa stamping? Just file a change of status. And they're like, oh, I didn't know that was an option. So yes, filing a change of status with USCIS is an option. It's the I-539 application. There is no biometrics fee. That's kind of one of the issues that we were having during the prior Trump administration. They added this biometrics fee for I-539s that slowed everything down. And so there was a problem there. And also there was no premium processing at that time. But since we have premium processing, no biometrics, if you or your child, whoever's changing status to F1, if they're in the US, and maintaining your current status, Absolutely, you can do it as a change of status without having to leave the US. And then once you do that, be aware that you don't have to get the visa stamp. You only need a visa stamp if you leave the US and are coming back in a different status in F1. But if you don't leave the US, you don't need to get an F1 visa stamp to activate it or anything like that. In terms of documents, we see a few requests for evidence from time to time. They're generally nothing out of the ordinary and pretty easy to respond to, but they are typically asking for some sort of written statement of your intentions. Why is it you chose this school? Why did you choose this field of study? What do you hope to gain from it? And what do you plan to do after your program is over? So that number one, they're trying to look at your intent. Are you truly going to be a student, or are you planning on getting this F1 so that you can work without authorization or do bad things that you're not allowed to do? And then what are your intentions afterwards? They want to make sure that you have non-immigrant intent, not immigrant intent. F1 is not a dual intent visa, meaning that when you're applying for the F1 at a consulate, when you're coming into the US at CBP, or when you're filing a change of status, you have to have the intention of leaving the US at the end of your program, and you have to have a residence abroad to return to. So your stay is only temporary. So having that written statement kind of helps alleviate some of that. They also want to see that you have the financial ability to pay for your tuition as well as support yourself for your first year of school. On the I-20 that you get from your school, there's going to be a dollar amount listed. You need to show where that dollar amount is coming from, whether that's your bank account, whether it's a parent's bank account, whether it's your 401k. There's lots of different ways to do that, but you do want to include that in the petition. And then in terms of proving that you have a residence abroad to return to, some people choose to submit this with the filing, other people choose to submit it in case there's a request for evidence. But whether you yourself have a place in your home country or elsewhere, or it's a family member or somebody that you can leave the US and go live there, they want documentation of that, whether it's a mortgage or a deed or a lease, or family members documents for that. I think those are really the main things they want to see. And we've had a lot of success with these. Because premium is available, we're not seeing the delays. We're not seeing the need to file these B2 bridge applications that we had to do during the first Trump administration, because your status was expiring and the F1 was still pending, and then they would move the program start date because your F1 hadn't been approved yet, and then they say, well, you need to maintain your status to the new program start date. So we'd had to file these B2 extensions and bridges and all of that. None of that's a requirement anymore. What are your thoughts on the F1 process these days? Is it something to be overly concerned about?
No, I mean, I do think, to your point, one, keep in mind premium is 30 business days for F1. It's not the 15 business days like most I-129s. So keep that, factor in. A lot of this is going to be talking with the school, getting the documents right from the school, paying the, SEVIS fee. And like Emily said, just submit the documents to show that it's kind of weird. You go to the school, you show you have the ability to pay for the tuition and all that in order to get the I-20. And then USCIS still insists on getting evidence to show that you can pay. And sometimes they don't understand what's going on. We're talking about parents doing it or whatever. So it's not uncommon to get RFEs on these things. Some of it, they just want clarity. It's not, there's something wrong with your case. But they're going pretty smooth, and I think it's I know we've seen attacks on student visas. It's still a good path for people who want to study, and it's an option. There's nothing wrong with trying to further your education. Ellie, we want to hit some of these questions. I see a comment here. Today's Visa Vibes on litigation was informative, so appreciate that. About take on YouTube. Thank you, sir.
All right. So Tharun from YouTube says, my perm was recently filed, but I plan to move from Austin to the San Diego branch within the same company. Do we need to cancel the current perm and file a new one for the new location? Is that required? Short answer, it depends. What does it depend on? Number one, was your perm filed for only a position in Austin, Texas, or did your perm allow for unanticipated work locations, which is very common in the consulting staffing industry, or did they allow telecommute from any work anywhere in the US? Other question would be, is this a temporary move? If your intention is to eventually come back and work in Austin, when you get your green card, then the perm is fine and can continue to be processed even if you're temporarily moving to San Diego. So there are definitely ways to keep the perm process going and not having to cancel and refile it, because that is going to add another 18 months to your process, because you have to get a new prevailing wage, do that's taking 5 6 months, do new advertisements, that's taking another 6 months. So you're basically losing a whole year on the process by canceling it. So if you can keep it going through any of those particular options, definitely a good idea to do.
Question from Raj on YouTube. Is USCIS adjudicating concurrent H1, H4, H4 EADs as of today? What's the current trend? I don't see trend lines on this. It's so weird. Some of them are processing concurrently. Some of them, there's a delay. I am not seeing, and Emily, let me know what you're seeing. I'm not seeing significant delays in the adjudication of H4 EADs. I mean, I've seen some maybe a few weeks, maybe a month, but I'm not even getting requests for the litigation like we did in 2018, 2019, or excuse me, 2019, 2020. I mean, I had a few that are kind of wonky, but I feel like they're fairly good. Obviously, there's exceptions to the rule, but even if they're not adjudicated altogether, they're fairly good so far.
Yeah, compared to what we were seeing before. I've not had many clients reach out to me and say, "Hey, my H-1B is approved, but what about the H-4 and H-4 EAD?" That because they are generally being approved relatively quickly after the H-1B is approved. Abiram wants to know on this LCA and work location issue. Interesting question. Can I visit my friend in a different state for a week and still work during that week? We said you have to have a LCA for the work location that you're actually working in. There is a short-term placement provision that allows a company to have someone work in a different location for up to 30 days if they meet certain requirements. So that might cover that situation as well. Um, I think it also depends, obviously, this doesn't change your permanent work location. I've never seen USCIS or the Department of Labor question someone being in a different state temporarily working remotely for a week. Definitely something to reach out to your company's immigration attorney to see if how they view that, but it's not something I've seen on anyone's radar.
A question here. My green card is currently pending under EB1C, and I got laid off. Can I do contractor or temporary jobs based off of my green card EAD? Gosh, it was one of those it depends questions too. When we talk about AC-21 and your green card, your I-485 pending for more than 180 days, the job that you take on, in order to get the green card, has to be in a similar occupation. Now, that is loosely defined, but when we're talking about EB1C, it's a little bit more strictly defined. You should be doing a managerial role. Now, I don't necessarily think now you have to take on a new international managerial role, but you should be in a managerial role.
Reshma says, if one is in the US on an employment-based green card expiring in 2031, but eligible to file for the N400 early next year, is it better to file for the N400 in 2029 rather than next year? Interesting question. I think for most people in the employment-based space that had a smooth process and no violations and no criminal issues to worry about, um, I would say file it sooner rather than later, because the earlier you become a citizen, the less the Trump administration can do to you compared to when you're still a green card holder. And we have not really seen much difference in the citizenship process, that extreme vetting. We're not seeing an impact on that really in the employment-based space. The process is still smooth as of now. I might change my answer in 2029, but even during the prior Trump administration, I did not feel there were any issues with employment-based permanent residents filing for citizenship, and they were getting processed smoothly and quickly, and no real issues there. So I think
Yeah,
it's worth it to convert as quickly as possible.
I actually had a meeting yesterday with some business leaders here in Houston, and they were talking about citizenship and how organizations can encourage employees to apply for citizenship. And to your point, Emily, you kind of think of immigration in tiers, and your non-immigrant visas, and then lawful permanent resident green card holders, and then citizenship. It's so hard to mess with you. We've seen in the news people, extreme circumstances, them going after green card holders. It's a lot harder to denaturalize someone. Okay, very, 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 very hard. So there are a lot of rules in place for citizenship and N400s and how to go about those. So I do encourage people to do it. I think it gives you as clean of a ground as you can, because other than not being able to run for president, I don't think there's much of a difference between a naturalized citizen and a natural born citizen under our laws. Question here that I saw: do we see any issues with traveling on H-1Bs who have already had visa stamping? I told someone this the other day. I do another podcast with some folks, and I was telling them, Emily and I are going to err on the side of caution, and people are going to call us fearmongers. My job is to let people know the risks of travel, and travel can go very, very bad. You could have a grumpy CBP officer, and they have discretion to deny your entry for any reason and then stick you with a 5-year ban. And so I'm always going to tell people, be cautious, especially in this day and age. And I told him, I said, more people have success with traveling in than don't. And so with the idea that things can always go wrong until you're a citizen, right? You could always have issues at the port of entry. We see more people having success with travel than not. I just would really make sure you've dotted your T's and crossed your I's. All right. Make sure your immigration paperwork is up to date. Make sure you're getting the right documentation for your companies. Make sure if you have to file an amendment, you have done so. I regularly have calls with our clients about, let's make sure John is good to travel. So it can be as smooth as possible. And even then, it's no guarantee. And I don't want to, scare everybody with it, but there is risks with expedited removal and all that. But more people have success with travel, especially if you have the visa stamp, than not.
Gori says, what is a level 1 versus a level 4 prevailing wage? So as we were talking about with LCAs, when the company files that, they select the wage level that is appropriate for the position. What is that based on? So there is a very specific worksheet in the prevailing wage guidance that I'll talk about in a second, but the basic is a level 1 is expected to be an entry level job, someone fresh out of school, no experience, very little authority or discretion. They're told what to do, they do it, and then someone reviews their work. Level 2 is considered qualified. So they're a step above entry level. Maybe they have 1 or 2 years of experience. They can do the job in a reasonable manner without as much supervision. Level 3, they look at basically, is this a senior level position? Is this called senior something? Is it the person a team lead? It is more than qualified and also potentially has some supervisory aspects to the role or mentoring aspects to the role, more discretion in the work that they're doing, more authority. And then level 4 is the top one. So that's if the role requires, they're supervising other people, they have a lot of discretion, they're very experienced, they, basically take a project and run with it, all of that. Now, in terms of the actual worksheet that you're supposed to fill out, so you first figure out what is the SOC code, the standard occupational code for that particular job based on the job duties. Each SOC code is going to have an SVP assigned to it, lots of acronyms here. That's specific vocational preparation. So Department of Labor for every single occupation code has decided what it takes to do that job, to be minimally qualified for it, or what's normal for that job. So they might say a job requires an SVP of 7 to less than 8. That's going to equate to a certain number of years of education and experience. So each range has a set number of years. And so if you are at the low end of that range, and there's nothing special, there's no special skills, there's no supervisory, there's no unanticipated work locations or travel involved, you could potentially be a level 1 position. If you are, still at the low end, but now you require some sort of special certification or a license or something beyond what's normal, then you have to add another point. Then if you have supervisory skills, you add another point. Now we're up to level 3. If you add even, if you're at like saying the job requires 10 years of experience when the normal range is up to 2 years of experience, well, now we have to add multiple points to get to a level 4 wage. So that's how DOL calculates that.
Yeah, and one of the misconceptions with this, Emily, is well, I've got a PhD, but I'm applying for a role at the McDonald's. Well, it's what does the position require, not what do you have. It's kind of when we're talking about wage levels. So just understand the difference here. Question here on YouTube. How long does it take to get the receipt number once the H-1B petition is filed under premium? I don't know. What do we see in 3-4 days, maybe from delivery, maybe the same day, kind of all over the place, depending on the lockbox. If it's been more than a week, maybe look into it.
Arun says, will it cause any issues for someone on H-1B to be a non-managing member of an LLC? This LLC is not connected to the work or industry of the H-1B job. It's not necessarily an issue. So when you're a non-managing member of an LLC, that basically means you're an owner and nothing else. So maybe you invested money as an owner, you deserve a share of the profits, whatever the members of the LLC have decided on, but you're not doing anything for the company. You're a passive investor. So in general, that is allowed. It's not considered to be unauthorized work because you're not working for the company in any way. The problem is when USCIS sees that your name is on this other LLC, they automatically assume you're working for that LLC because you're an owner of that company or you're listed on some document. So it's your job to prove to them that you are not working for the company. Then it becomes even more of an issue if that company is doing anything in the immigration space. If they are hiring workers on OPT or STEM OPT and that LLC is filling out training plans, if they're sponsoring H-1Bs in the lottery and signing H-1B paperwork on behalf of other immigrants, and your name is involved somehow, even if you're not doing any of that, it can come up at your 485 interview. It can come up at your citizenship interview, especially if that LLC did anything remotely wrong or what looks to be wrong. So you've got to be very, very careful to make sure, even if it doesn't impact your H-1B job because you're not working without authorization, it may have long-term consequences that might be too much of a risk for you if you don't want your green card to be in jeopardy.
Question that I just saw here. This is kind of an interesting one. Meet on YouTube. I stayed on H4 for 2 years. If I decide to get F1 later and then get H-1B, well, I only have 4 years on H-1B because I've had 2 years on an H visa. The answer is no. You get 6 years on an H-1B. It is only subtracted by times on H-1B or L1 visa, not a dependent visa.
Ray Stays says, how about concurrent startup H-1B, where someone wants to keep working in the current company and also start a company on the side? I'm glad you mentioned that because that's something I wanted to point out when Stephen was talking about the wage issue that, these startup companies have to be able to pay the wage. Well, it may be necessary for you to do part-time employment to be able to afford the wage, or maybe do this concurrent. So yes, absolutely. If you are going to stick with your current company and kind of do the startup work on the side, you can absolutely do a concurrent H-1B for that. And all the same rules apply with a concurrent H-1B. It can be part-time, it can be full-time. Even a regular H-1B with a startup can be part-time or full-time. If it's part-time, you can specify the number of hours a week that the person will work. It can even be a range of hours. So maybe 1 week you're going to work 5 hours on it, another week you're going to work 20 hours on it. So definitely an option, and not really seeing any issues with that.
A question from YouTube. Individual is currently in Canada. He has a 2015 priority date. Employer is willing to file for EB1C. Can the I-140 be filed while he is in Canada, or is it advisable to file it after he's back in the United States on L1A? If you qualify for the EB1C, you do not have to be in the United States to file it. I've done that before. An individual who wanted to file, but he wanted to also let his child finish out the school year. No issues with that. And then, you can file. I think 2015 is current for everybody on EB1. So you can file the 485 when you're back in the US on L1A. No issues with in Canada, back in the US at all. It has no bearing because it really doesn't matter that you're on L1 when you file for the EB1C. It's going to be kind of re-adjudicated.
Pranav points out that USCIS archived their guidance about doing the change of status to B2 in the event of job loss, which is correct. That happened a few weeks ago. So he wants to know, are we seeing a trend of denials for I-539 petitions or a change of status back to H-1B when the I-539 is still pending for cases that were filed before May 27th when this website was archived? We have not seen one denial in our office, and I'm not aware of any others from other attorneys as well. So as of now, although yes, that web page has been archived, we are continuing to file change of status to B2 who are in that situation. And we've not seen any denials of people that have already filed these. Now, it might be too soon to expect that. So maybe in a couple of months, we might start seeing that as USCIS gets around to adjudicating the B2s that have been filed recently. But as of now, nothing has actually changed that we're seeing.
Question on YouTube. If the interfiling EB3 to EB2 485J is still pending with no status update since it was filed 3 years ago, can I consider that I'm still under EB3? Very good question. USCIS, I don't know. They don't always update the case status page, right? I don't know if they process all these 485Js always right, especially with the downgrades. I just had a case that we litigated the 485J, the I-485 delay case. And the government attorney called me up. He said, we still think he's in EB2. I was like, no, he filed to EB3. They're like, can we just get something that says he wants to be in EB3? And I said, yeah, we can do that. And lo and behold, it got adjudicated very quickly after sending in a tub letter. They even said later, oh, we want a 485J. And I sent in a soft copy that was approved the same day after we had, filed the lawsuit. And they kind of reached out to us on resolving it. So, I don't really have a good feel on what they know in their database. And sometimes we learn in litigation what they think is different than maybe what you think. And we just kind of bob and weave with those 485 delays.
My act says I have an approved I-140 through EB2 NIW, and is my spouse eligible for the H-4 EAD? And is it better to apply for the change of status in H-4 EAD in the US, or get the H-4 visa in India and then apply for a standalone H-4 EAD? So yeah, she's absolutely eligible for the H-4 EAD. No issues there based on your EB2 NIW case that's been approved. In terms of the better way to go for it, so I think it depends on the her current, I'm assuming a woman, her current status. If she's already in a work authorized status, like maybe she's on her own H-1B, then it makes sense to file a change of status to H-4 plus H-4 EAD together. Most of them are approved together so that she can seamlessly switch from H-1B to H-4 EAD without any gap. Now, there is some risk of a gap if the H-4 and H-4 EAD gets separated for some reason, which is not happening very often. Most commonly, it's because there was something missing from the EAD application, so they can approve the H-4, but they have to send a request for evidence on the EAD. If that happens, once the H-4 is approved, she's got to stop working until the EAD gets approved. That's the risk there. But if you plan on having her apply for the H-4 visa in India and then applying for the standalone H-4 EAD, she has to come back to the US in H-4 first before she can apply for that EAD. That means she can't work once she's in the US on H-4 until the standalone EAD gets approved, and that could be several months. So if she was in a work authorized status and then comes back on H-4, she has to stop working until the EAD gets approved, which can be several months. So for that reason, generally, it makes sense to file it as a change of status and file the two applications together.
A question here on YouTube. It's kind of a two-part question. I'm on H-1B 2015 EB2 priority date. Also applied for an EB5. Wife is the primary. Want to travel, come back on advanced parole, continue to work on H-1B. Can I transfer the H-1B when I come back in and apply for perm and I-140, porting the 2015 priority date with the wife's company? So you can continue your H-1B status when you leave maintaining your H-1B status and come back on H-1B status, and then do the transfer. We've had success with that. You may run into issues though with the perm with your wife's company because of the familial relationship. It's kind of a red flag to begin with. It's not to say that it's impossible. It's just an audit risk involved with that.
Uday from X says, is it possible to transfer an H-1B that was approved via consular processing to a different employer and this time file it as a change of status? No, it is not. So just getting a consular processing H-1B approval does not yet mean that you have been counted in the lottery. So even though you got the selection notice saying you were selected, even though you got an approval notice saying you're approved, what makes you counted in the cap is either getting the visa stamp in your passport or actually being admitted to the US in H-1B status. So actually changing status or traveling to the US in H-1B status. Since neither of those things have happened yet, you can't take that consular processing approval and send it to another employer and have them file your H-1B. You would have to get the visa stamp with the first company and then have a company file if you're outside the US consular processing, and then you come in with the new company's approval and the old company's visa stamp. Now, back in the day, it was possible because USCIS was very inconsistent in how they were applying that. But they did start denying applications filed by the other company when the initial H-1B in the lottery was approved for consular processing and no visa stamp was issued.
Question from YouTube. EB3 rest of world TN visa. My priority date is 2023 and my filing date is current. Should I take any action now? And I don't remember. I've been out of the office a little bit. Are they taking the final filing date or the final action date right now? I assume it's final action right now, right?
Yeah. Hmm.
Yeah. So, if it's only your filing date that's current, what I would maybe do is start getting your documents together, right? Because it's very possible. I guess we're in the last quarter, or about to be in the last quarter here. We're towards the end of the fiscal year, the back half of the fiscal year. And if your filing date is current, eventually either one of these months they're going to use the filing date, or come October, you're likely to become current and they take the filing dates. Just I would start getting documentation together and to do your I-485, whether it becomes something you can file this summer, hopefully, or right there at the beginning of October.
Foodie Run says, I'm on H4 EAD. Am I eligible for automatic revalidation if my expired visa is in an expired passport? I have renewed my passport while in the US and have the valid I-797. Yes, as long as you have the expired passport with the expired visa in it, the actual document, yes, you still are eligible for automatic visa revalidation, even though it's in an old passport.
Question: any impact on traffic tickets for speeding or illegal U-turns? Don't do them. But no, I mean, from an immigration perspective, we saw some reckless driving issues with regards to the student visas where they were terminating them. In some states, if you have reckless driving, if it's like 15 miles an hour over, it's a criminal matter. And they did stuff with the F1 visas. I have yet to see that with any other visa category, and they got slapped pretty hard on the F1 issues. I mean, I wouldn't do it. I wouldn't think we're going to see too many issues with traffic issues moving forward.
Promote says, my mom visited the US for 5 months approximately, and then left for 7 months, and now she's going to come back again for another 4 months. Are there risks or concerns due to the length and the timing? Not particularly. So there's nothing wrong with this situation, but just because your mom has a valid 10-year visa doesn't mean she's guaranteed entry every time for every stay. So the risk is when she's coming back for this 4-month trip is she still has to convince this CBP officer that she is coming for the purpose of visiting. She is coming temporarily. She has plans to return back to her home country. She has a residence abroad to return to, and she has the financial means to support herself. So if she fails on any of those, regardless of the prior stay in the US, and she's only been out for 7 months, they can deny her entry for any of those reasons. So they're not going to deny simply because she visited before and now she's visiting again after 7 months. They will deny if they think that she is coming permanently, that she doesn't plan to return home this time. And the trips being a little close together could weigh on that, but it's not the determining factor.
Good question here on YouTube. Currently on H-1B, want to apply for H-4 EAD. My current H-1B ends next month. Can I stay in the U.S. based off the change of status applications? Yeah. If you file before your H-1B expires, I assume that's when your I-94 is expiring, or if you're just being terminated, as long as you file before your I-94 expires for that change of status, you can continue to stay in the United States on a period of authorized stay while it's pending.
Zorav says, if an RFE for an I-140 is replied to late, does it raise any red flags? Mine is 45, I'm assuming days late as of today. So if you're saying that the deadline to respond to your RFE was like April 31st, April 30th, I guess there is no 31st of April, and it hasn't been responded to, Does it raise a red flag? No, but it will cause the denial. It's considered abandoned if the company doesn't respond timely. So I don't know if I'm misunderstanding the situation or your question, but if you miss the deadline of the RFE response, they will deny it, even if it's just by 1 day. You can always refile it, but you have to pay the fees again. All right, well, it looks like we are out of time for today. Thank you everyone for joining. As usual, we will be back next Tuesday live at 5 o'clock Central Time. And if you didn't get your question answered, remember we do have a free Zoom call every day that you can join, or you can always set up a consultation with either of us or any of our attorneys here at Reddy Neumann Brown by going to RN Law Group.